Welcome back to online classes. Dear students, how are you? I am James here. Today I am going to discuss with Indian Penal Code. Okay? IPC. Section 340 explain about wrongful confinement. Wrongful confinement. Okay. Here, whoever wrongfully restrains any person in such a manner as to prevent that person from proceeding beyond certain circumscribing limits is set wrongfully to confine that person. Okay, wrongful confinement. I'll give you illustration based on this section. Here A is a person. A causes Z to go within a walled space and locks Z in. Z is thus prevented from proceeding in any direction beyond the circumscribing line of wall. Here A wrongfully confines Z. Okay. And second illustration, here A is a person. A places men with firearms at the outlets of a building and tells Z that they will fire at Z if Z attempts to leave the building. Here A wrongfully confines Z. What is my comments in this section? Wrongful confinement, which is a form of wrongful restraint, is keeping a man within limits out of which he wishes to go and has a right to go. Okay, based on this section, this two ingredients is available. What is that? Number one, wrongful restraint of a person. Wrongful restraint of a person. Number two, the such restraint must prevent that person from proceeding beyond certain circumscribing limits. The offence of wrongful confinement as defined under section 340 of Indian Penal Code occurs when individual is wrongfully restrained in such a manner as to prevent him or her from proceeding beyond certain circumscribing limits. Okay. And wrongful confinement and wrongful restraint. What is that? Wrongful confinement and wrongful restraint. From the definition, it is evident that wrongful confinement is a species of wrongful restraint as defined in section 339 of IPC. While in wrongful restraint, there is only a partial suspension of one's liberty, wrongful confines reflects total suspension of liberty beyond certain prescribed limits. Okay, the period of suspension is immaterial for constituting an offence of wrongful confinement or wrongful restraint. When a person is restrained and is prevented from going where he has right to go, the restraint become wrongful if such restraint is not in exercise of any right, power or authority under any law. Okay. Okay, I will give you one or two points based on this section. First point, prevent that person from proceeding. The restraining of a person in a particular place or the compelling him to go in a particular direction by force of an exterior will overpowering or suppressing in any way his own voluntary action is an imprisonment on the part of him who exercise that exterior will. Okay, there can be no wrongful confinement when a desire to proceed has never existed, nor can a confinement be wrongful if it was consented to by the person affected. Okay, mere insistence by words of mouth or mere sitting around a person would not satisfy the requirements of the offense of wrongful confinement, which requires that there must be voluntary obstruction to that person so as to prevent that person from proceeding in any direction in which that person has a right to proceed. To support a charge of wrongful confinement, proof of actual physical restraint or restriction is not essential. It is sufficient if such evidence shows that such an impression was produced on the mind of the victim as to create a reasonable apprehension in his or her mind that he or she was not free to depart and that he or she would be forthwith seized or restrained if or she attempted to do so. The second point of view, certain circumscribing limits. What is that? A prison may have its boundary large or narrow. Okay, visible and tangible. Or though real still in the conception only, it may itself be movable or fixed. But a boundary it must have, and that boundary the party imprisoned must be prevented from passing. He must be prevented from leaving that place within the ambit of which the party imprisoning would confine him except by prison breach. Some confusion seems to me to arise from confounding imprisonment of the body with mere loss of freedom. It is one part of the definition of freedom to be able to go whithersoever one pleases. But imprisonment is something more than the mere loss of this power. It includes the notion of restraint within some limits defined by a will or power exterior to our own. Okay. Another definition of this section, forced to walk. If ever a person was forced to walk under duress, du or ess, duress to a particular direction, it amounted to an offense of wrongful confinement. An act by which a person is prevented from proceeding towards a particular direction is an offense under the sections. Okay, and another thing, period of confinement. How much period? The time during which a person is kept in wrongful confinement is immaterial except with reference to the extent of punishment. Okay, I will discuss with the example of cases based on this wrongful confinement. When two police officers arrested without warrant a person, warrant from the court, who was drunk and creating disturbance in a public street, and confined him in the police station, though one of them know his name and address, and it was not found to what extent he was a danger to others or their property. Okay, then It was held that the arrest having been made by the police officers without warrant for a non-cognizable offences, their action amounted to wrongful confinement unless it was justified on the ground of right of private defence under section 81 of Indian Penal Code, as was in fact held by the court. Okay. The same section apply though an illegal search in violation of the provision of section under section 165 of CRPC. This is another example of this related section, but this is criminal procedure code, how the police officer will do the work. Though an illegal search in violation of the provisions of section 165 of CRPC can be resisted, there is no justification for bodily lifting and bringing back the investigation officer after he has left the house and to confine and threaten him till he gives a written statement, and that he has searched the house of the appellant. It was held that by such acts as the accused had committed offence of wrongful confinement and assaulting a public servant within the meaning of under section 342 of IPC and section 353 of IPC. Okay. And another example, a police officer arrested and detained a person in the Thana, that means lockup, despite production of a bail order from the court. What will happen? It was held that the officer was clearly guilty of an under section 342 of IPC. Okay, I will give you another point of view. Custody of child. What happened? Custody of child. It is an incorrect preposition of law that a father would never be held liable for offence of wrongful confinement. It's right. If he detains the child by having snatched her away from the mother, who under some authority of law had at the time of snatching, the custody of child and is entitled to have custody of the child. When a minor is kept against the will of the person who has the custody of the child, okay, and or who is entitled to take the custody of child, such detention would amount to wrongful confinement. In such a case, it is the will of the person who is entitled to have custody of such a child, which will be the will of the child, for the child's willingness or consent would be immaterial unless the welfare of the child. In a given case, it demands removal of the child from the custody of the person who is otherwise entitled to keep the custody of the child. Guardian and custodian are not synonyms with each other. Thus, even when a parent who with impunity snatches away a child from the lawful custody of the other parent, who held such custody and who is entitled to have the custody of the child under the law, personal, statutory or otherwise, such snatching away of the child and is detention against the will of the parent in whose custody the child was would amount to an offence of wrongful confinement. And another point of view, what is that? No wrongful confinement. No wrongful confinement means, the example, where the wife who has attained the age of 21 years stated before the court that she was not detained by her parents against her will. There was no wrongful confinement, and as such the habeas corpus petition before the court by the husband could not succeed also. Okay, students, we discussed about the ingredients. What is section 340 explain wrongful confinement? What is the meaning of wrongful confinement? If it is violates, what are the punishments? If we are going to refer the punishment area, the under section 342 of IPC explain about punishment for wrongful confinement. Okay, what is that? Whoever wrongfully confines any person shall be punished with imprisonment of either description for a term which may extend to 1 year, or with the fine which may extend to 1000 rupees, or with both fine and jail. Okay, based on the section 342 of IPC, a small the comments. This section 342 IPC is not confined to offence against public servants, but is a general section and makes a person who wrongfully restrains another. Okay, guilty of the offence under the section, a wrongful confinement is a wrongful restraint in such a manner as to prevent that person from proceeding beyond a certain circumscribed limits. The offence has nothing to do with the investigation or search. Okay, the main essential ingredients of the offence wrongful confinement are that the accused should have wrongfully confined the complainant, and such a restraint was to prevent the complainant from proceeding beyond certain circumscribed limit beyond which or she has right to proceed. The factual scenario clearly establishes commission by the appellant as well as the offence punishable under section 342 of IPC. Confinement need not necessarily be confinement where the person is physically held within a certain circumscribed limit. To support the charge of wrongful confinement, proof of actual physical obstruction is not essential. It is the condition of the mind of the person confined, having regard to the circumstance that leads him to reasonably believe that he was not free to move, and that he would be forthwith restrained if he attempted to do so. Okay, and another point of view, where a man illegally taken into police custody was beaten by the police and he committed suicide. What will happen? The accused police officials were punished under section 342, case under section 352 and 302 was not made out. Only see 342. Okay, students, and another part of section also available, same section, wrongful confinement. Okay, but based on this confinement, the imprisonment also increase. Okay, we'll see one by one. Section 343 of the IPC explain about wrongful confinement for 3 or more days. 3 or more days wrongful confinement. Okay, here whoever wrongfully confines any person for 3 days or more shall be punished with imprisonment of either description for a term which may extend to 2 years, or with fine, or with both. Okay, here whoever wrongfully confines any person for 3 days or more shall be punished under this section. Whoever wrongfully restrains any person in such a manner as to prevent that person from proceeding beyond certain circumscribed limits is not necessary for the offence of wrongful confinement. A mere detention of a person against law would attract section 343 of IPC. Okay. And section 344. What is that? Section 344 explain about wrongful confinement for 10 days or more days. You just note down days of the confinement. The earlier section explained about 3 or more days. Okay. But the punishment extended to 2 years or with fine. Now this section explained about 344 of IPC, wrongful confinement for 10 or more days, 10 days, minimum 10 days or more days. What is the punishment area and what are the conditions here? Whoever wrongfully confines any person for 10 days or more shall be punished with imprisonment of either description for term which may extend to 3 years and shall also be liable to fine. Okay. And section 345 of IPC explain about wrongful confinement of person for whose liberation writ has been issued. What is that? Whoever keeps any person in wrongful confinement knowing that a writ for the liberation of that person has been duly issued. Writ means before any one of the aggrieved person already filed before the High Court and got writ of habeas corpus. That means to produce the body before the court. Produce the body means produce the person, particular person who is a missing person, to produce before the honorable court. Okay. So that writ also duly issued. In this situation, knowing that particular person, what will happen? That wrongful confinement shall be punished with imprisonment of either description for a term which may extend to 2 years, in normally 2 years, in addition to any term of imprisonment to which he may be liable under any other section of this chapter. Okay, it will be added. Depends upon situation, depends upon inherent of the court. Okay, and another section, section 346 of IPC, wrongful confinement secret. That means secret place. That in that particular person will not inform to any other person, hiding. Okay. Here, whoever wrongfully confines any person in such manner has to indicate an intention that the confinement of such person may not be known to any person interested in the person so confined, or to any public servant, or that place of such confinement may not be known to or discovered by any such person or public servants as herein before mentioned, shall be punished with imprisonment of either description for a term which may extend to 2 years, in addition to any other punishment, note down, any other punishment to which he may be liable for such wrongful confinement. That means at the time of particular way, particular time, in addition, may prescription punishment will be added. Okay. Section 347. Next section 347. This section also explains about wrongful confinement to extort property or constraint to illegal act. What is that? Extort property, to threatening any one of the person and taking property from that confined person. Okay, or to do illegal act. He instigate to do illegal act. So he is extorting to that confined person, that aggrieved persons. Okay, here whoever wrongfully confines any person for the purpose of extorting from the person confined or from any person interested in the person confined any property or valuable security, or of constraining the person confined or any person interested in such a person to do anything illegal or to give any information which may facilitate the commission of an offense. Okay, to do anything illegal or to give any information which may facilitate the commission of an offense shall be punished with imprisonment, either description for a term extended to 3 years, and also liable with fine. Okay, this under the next section also be compared with the section 329 and 330, as the aggravating circumstances mentioned in the former are the same as those in the later also. What is the later section? Section 348 of IPC. What is that? Wrongful confinement to extort confession or compel restoration of property. Confession statement. He is asking to confess a statement, the mode of through threatening or extorting. Okay, or compel restoration of property. He is receiving the property from confined person. So here, whoever wrongfully confines any person for the purpose of extorting from the person confined or any person interested in the person confined any confession or any information which may lead to the deduction of an offense, okay, or misconduct, or for the purpose of constraining the person confined or any person interested in the person confined to restore or cause the restoration of any property or valuable security, or to satisfy any claim or demand, or to give information which may lead to the restoration of any property or valuable security, okay, shall be punished with imprisonment of either description for a term which may extend to 3 years, and shall also be liable to fine. Okay, what is that? In the view of section 348, this section may be compared with section 330 of IPC. The former case, confession is extorted by wrongful confinement. In the later, by causing hurt. To prove an offence under this section, it is not necessary to show that a formal arrest was made. It is enough if it is shown that the person was prevented from proceeding beyond certain circumscribed limits, evidence showing that the deceased died of multiple injuries, and such injuries are caused only when deceased was in illegal custody of accused. Accused is held liable to be convicted under section 348 and 304 subclass part 2 of Indian Penal Code. Okay students, now this part is over. What is that? Wrongful confinement. Okay, up to section 340. This section is very big portion. Section 340. Okay, and section 342 is the punishment for wrongful confinement, and 43, 343, 344, 346, 47, 48 also the extended limit of the punishment based on this confinement of days. Okay students, we'll meet you again next video class with good lessons. Okay, those who are not subscribed this online classes, please subscribe immediately. Enjoy with your legal mind. May God bless you. Thank you.